following program on Other Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the international context of the use of force. What key pieces of legislature governs the use of force, and what nuances are there in the current context? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty. Now, today's topic is one that is not usual for our programs, and that is, of course, we usually take a very local perspective, a Lankan focus on even the law and legislative updates that are surrounding the country. But today we're going to step back a little bit and get into focus on the international aspects of law across the globe. Now, and for that, today we're going to start off with the use of force. Now, the use of force is a topic that's very vast and has not been completely discussed in the current context for our country specifically, but we have seen it popping up due to recent conflicts that have happened across the globe over the past few months and over the past year. So to speak to us a little bit about the use of force is someone who I believe is extremely experienced in this field, and that is Attorney at Law Udara Soysa. Thank you very much, sir, for taking the time to speak to us today and to enlighten our viewers. Now, a small introduction on Mr. Udara Soysa. He is, apart from being an attorney at law, he is a published author, he's a senior law lecturer and a lecturer in charge for international law for postgraduate programs at the Bandaranaike Center for International Studies at BMICH. So, needless to say, he is very well versed in this specific area and we're going to get a lot of key information regarding this topic. But before we delve into the topic, here's a little bit of a breakdown for you on what we're exactly going to be discussing. First, we'll be talking about the fundamentals of the use of force in an international context. What are the key pieces of legislation, or what are the key instruments that govern the use of force? And next we'll be talking about the technicalities that come with the use of force and the legislation surrounding it, and how it has been applied in the current context. And finally we'll be talking about the use of force and the future in an international arena.
Hello, my name is Vidusha Jayawardena and I'm a fashion student. My question is on the fundamentals of use of force. What are the key international instruments governing the use of force?
Alright, without any further ado, let's get right into the discussion. Now, sir, thank you once again for taking the time. It's a very important subject, especially with the key updates that are happening right now. But before we get into any of the current technicalities, I feel like it's important for our viewers to understand the very basics, the fundamentals of the use of force. So could you explain to us a little bit about the definition of use of force? What exactly is the use of force?
A great starting point, right? So when it comes to a definition of use of force, you don't have a clear-cut, black and white definition of use of force, but there are enough international instruments, whether it's from UN Charter or whether there are Security Council and General Assembly resolutions, to give us a basic spectrum of what is use of force. So the starting point is use of force is prohibited in terms of being a tool in managing international relations as per Article 2.4 of the UN Charter. But since you asked for a definition, I think a good starting point is basically the resolution, General Assembly Resolution 29/3314 in 1970, which defines, they are linking use of force with aggression. So aggression is the use of armed force by a state against the sovereignty, territorial integrity and political independence of one state against another state. So example, if Sri Lanka attack Maldives, what would happen, right? We are violating that sovereignty, territorial integrity as well as the political independence of Maldives. So this is totally prohibited. So in a general sense, right, use of force can be defined in a very layman term, one country attacking another country. But this is only covered within the scope of military force. So for example, as per the judgment of Nicaragua versus USA, if one country use economic sanctions against another country, this would not count as use of force. So remember to keep the definition of use of force within an armed military intervention context.
Right. So, sir, now that we have a little bit of a basic circling of exactly where the demarcations of use of force and what it applies to, I think it's important for us to get a little bit of an idea on what governs the prohibition of use of force. Could you tell us a little bit about the key instruments? You mentioned the UN Charter as well, sir. Could you tell us a little bit of where it has been enshrined and which key instruments are responsible for the governance of this?
Excellent question. So, I think your starting point would be the Article 1 of the UN Charter, which tells all the states, member states of the UN, to use peaceful mechanisms to resolve the disputes. Article 2.4 of the UN Charter is very clear. Right? Article 2.4 is the backbone against the prohibition of use of force. Article 2.4 clearly says that all members should refrain from using military or use of force in governing the international relations. This is supported by a very important UN General Assembly resolution, which is the resolution 2625, which is in 1970. Further says that every state has a duty to refrain in its international relations from use of force or, listen carefully, threat of use of force. So, for example, not only use of force, but even threatening another country with use of force. That also is prohibited under the international legal framework. And thirdly, we can come to the General Assembly resolution on aggression. And remember, we are not talking only about direct attacks. Sometimes we are also focusing about indirect attacks. So, for example, if Sri Lanka supports some terrorist group or some other groups within Maldives or any other country to engage in some type of a military attack or military terrorist guerrilla warfare, this can also come under the prohibition framework. So, you can break this down to two types of use of force. One, direct attacks and indirect attacks. Now, going further, we need to understand, now you might ask, so under what exceptions can we use force? So, there are two exceptions that allows state to use force. Obviously, all these exceptions are in the UN Charter. UN Charter, Article 51 of the UN Charter allows a state to use force when it comes to self-defense. We will discuss that a bit later. The other rather impractical exception is the Chapter 7 Security Council's ability to use force, right, under Chapter 7 of the UN Charter to use force to maintain peace. As you saw when Saddam Hussein in 1991, in 1990s invaded Kuwait, you saw how UN Security Council got involved, right? So we'll discuss that a bit later as well. So if I have to break this down, as per Article 2.4 and as per numerous UN General Assembly and Security Council resolutions, use of force is generally prohibited. However, there are two exceptions. There are two exceptions where a state can use force. As I told you, Article 51, self-defense, and obviously Chapter 7 of the UN Charter, which allows the Security Council to use force to maintain the world order and the world peace. Without, other than these exceptions, as per the settled international legal frameworks, there's no exceptions where a state can use force.
I see, sir. So historically, now thinking of it in retrospective manner, has it always been these clearly defined, the exceptions and also the means and how it has been defined in the current charters? Historically, is this how it came to be currently, or has it always been this clearly demarcated?
Excellent question. I think this is one of the most important questions for any scholar or any layman who would like to learn about international law to understand obviously the history. Historically, let's say we go in a time machine back to 500 years or so ago, you will see there was no real clear-cut prohibitions for use of force. As you see, when one country wants to attack another country, sometimes they might send some kind of a messenger, but usually when a country wants to attack another country, this was allowed. So you see so many battles in the past, whether it's Napoleonic warfare or Vikings warfare back in hundreds and years ago. The use of force was not prohibited under international law. So historically, the ability for a state to wage war against another country, it was open and it was allowed. However, as we became civilized, as the states became civilized and as people became civilized, then they realized there has to be certain limitations. So you can look at basically the World War I, in which around tens of millions have died, and then after the ending of the World War I, then civilized nations, the European nations realized, well, this is dangerous. Right? You had aeroplanes coming up, machine guns coming up. So the states realized the harm that each state could do to another using use of force. So in 1928, I believe, right, during that time, there was no United Nations. It was earlier something called League of Nations, which was, you can say, the father of United Nations. So under the auspicious support of League of Nations, there was this Kellogg-Briand Pact, which totally prohibited, right, the war. And you might see, but this is obviously not practical, right? After this, despite this prohibition, with Treaty of Versailles failing in 1930s, etc., you had in 1939 to 1945, you had the World War II, and as you know, it's a horrendous war, and almost 2.8 million Russians died, altogether really 6 million, right? Conservative estimate people dying. Then after the ending of the World War II, you could see that the states really realizing that we have to come with a practical limitation for use of force. Now, with the ending of the World War II, now we are having situations in which states got together, right, with the liberal viewpoint coming up, with United Nations coming up. The United Nations Charter was developed, and also additional resolutions and conventions were developed to limit the use of force and what type of force that can be used in warfare. So we'll discuss that later.
Exactly. So we do have to get into the technicalities as well. But before that, sir, I'd like to ask you now, we spoke about the history, how it came to be and how it's currently enshrined in UN charters and certain resolutions that are coming by the UN. Could you explain to us, sir, about the institution? Now, is it the UN, now that the law, the regulations have been enshrined there, is the UN the same institution that handles cases of use of force, or how is that dealt with?
Another great question. So there is no real central body. Now, before we go in, if I may, I would like to give you a basic viewpoint about international law. So international law is not a vertical system where in a vertical system you have the state and you have the subjects. So that's a vertical system in which it's a system of now domestic system is a vertical system where the government tells you, let's say the government tells you to wear the mask and you wear it, right? Otherwise the police or health officials might give you sanctions. But international law is rather what we call is a horizontal system of law. So what do you mean by a horizontal system of law? Horizontal system of law means there is no central law-making authority, there's no central law enforcement authority, no, there's central compulsory judicial authority. Many think there's International Court of Justice, but it is not a compulsory court. It is just when two countries want to resolve disputes, they come to International Court of Justice. So in terms of practical institutional aspects of use of force, the only institution that has some semblance of control over this would be the UN Security Council. So, for example, if a state is engaged in horrendous use of forces, and as you saw with the Iraqi behaviors in 1990s, etc., UN Security Council can practically try to get involved, right, or intervene. But the biggest problem is the politics in the UN Security Council. Now I'll tell you what these political aspects of this institution. Now you have these permanent 5 states, we know, US, UK, Russia, right, China and UK. Right? So all these powerful countries can veto any actions done at the United Nations Security Council. So now, for example, we know that when United States, without any UN Security Council resolutions, etc., went to war in Afghanistan or even in Iraq, practically there is nothing much that can be done at United Nations Security Council, because United States is also a member at the Security Council. So same way if you look at the Ukraine conflict as well. So practically UN Security Council is a bit helpless, because of course the matter of Russia annexing whether Ossetia or Crimea or general areas of Ukraine can be brought in front of the United Nations Security Council, but for sure China and Russia will definitely veto it. So one of the issues that we see, imagine for example Sri Lanka invades Maldives. I know it will never happen, but suppose a hypothetical situation. Technically, practically actually, we can get our supporting states or friendly states in United Nations Security Council to block any resolution or any attempt to hold ourselves accountable. Right? So this veto mechanism, that is seen very clearly in United Nations Security Council has historically weakened its functional effectivity as a enforcement body to control the use of force by countries. There are only several occasions where UN as Security Council has successfully used its power, and one obviously being the Iraqi conflict. But generally, if a state is able to veto the action in the Security Council, the Security Council is unable to take any action. So this way, there's no real enforcement or any controlling mechanism to control the use of force in international law. Unfortunately, this is the reality.
Yeah, due to the nature of this system, it is not directly linked, and therefore there is no direct obligation. There is veto powers. Of course, it's a complete global community, of course, and so there is quite a bit of complexity and nuances when it comes to this. But I feel like it's a very important question to ask about the justifiability of certain aspects of the use of force. Could you explain to us instances where there has been, certified proof of such use of force being justified by institutions? Right.
So now, basically, I can give you this United Nations Security Council Resolution 662 in 1990. So basically what happened with Saddam Hussein expanding his horizons in Middle East. So Saddam Hussein invaded Kuwait. So Iraq invading Kuwait, and there were clear evidence of this invasion, and Saddam did not have so much support from a lot of countries, even powerful states also. And remember, in 1990s, the earlier USSR has collapsed. Right? China was also developing its friendly relations with US at that time. So due to these political circumstances back in 1990s, United States was the only superpower at that time. Right? Nobody would go above the dictates of United States. So in that context, US was able to convince NATO without getting any vetoes to use force against Iraq. So when it comes to that, the United Nations Security Council would require clear evidence of aggression. For example, suppose the situation is between two countries, let's say India, Nepal, whatever, right? So there has to be clear invasion or aggression where you can see that the Indian forces have now crossed over to Nepal, right? And you need to have evidence, and in this day and time you will be able to find that evidence very easily, right? And also you have to ultimately understand this is beyond international law sometimes, because this could sometimes come to the areas of international politics. There are so many situations where countries have illegally used force so many times, and you see now even in Ukraine. But if the enforcement bodies are not equipped to fight and push back, then the whole international law mechanism is weakened. Right. And it is not very effective. Unfortunately, that is the situation. Even going to Ukraine conflict, you see the same thing. So if why wouldn't UN Security Council intervene? You can see a clear Russians have now crossed the border, right? Under whatever the pretext that is, clear evidence is there. You can see from not only from the US satellites, for everybody that you can see, even the Russia is not also denying that they are now in Ukraine, right? They're attacking, but nothing is being done, right? I mean, what other states can do is obviously other states can support through NATO, etc. You can support Ukraine, but whether legally, despite all the evidence, whether there could be a global UN Security Council effort against Russia, it's impossible because you cannot pass that.
Yeah, there's a lot of politics at play as well. It's not purely judicial process or legislative process. There's a lot of international relations to come into this as well, but that is a completely different nest. But we do have to talk about the technicalities as well regarding the Ukraine-Russia conflict also as an example. But before we go into any of these technicalities, let's go in for a very short commercial break. You're watching Law, Land and Liberty. Stay with us.
Hello, my name is Dikshaki and I'm a law student. My question is on technicalities. How does the current context approach the prohibition of use of force?
Welcome back to Law, Land and Liberty. We were in discussion with attorney at law Udara Soysa, and we were talking about the use of force in an international context. Now, before we went in for a break, we were talking a lot about the current context, but mostly about how it historically came to be and the demarcations of use of force, what institutions govern this prohibition and what exceptions are there. And before we left off, we were talking a little bit about the political aspect as well when it comes to the justification of use of force and how it changes over different situations. So I think it would be appropriate for us to move into the technical aspects of this this piece of legislature, or this resolution, one would say, or this instrument. And that would be about the different levels of force. Now we would talk about the justifiability of this entire aspect. Could you explain to us about are there different levels of force that have been recognized? And if so, are there different regulations and different definitions of these levels of use of force?
Again, excellent complex question, right? Now, when we are looking at use of force, what you need to understand is when you look at a UN Charter, you don't see a certification or some kind of a classification of use of force within the UN Charter. UN Charter it clearly prohibits use of force. But when you look at certain resolutions or certain practical aspects also, now with the technology now developing, right? Now there are a lot of new types of weaponry that is available than in 1940s when UN Charter was introduced. So for example, if you want to think legally and practically in terms of different levels, you can think of obviously conventional weapons. There is no prohibition for the use of conventional weapons provided that you have a justifiable ground to use of force, let's say under Article 51, right? Now there is a very interesting case called this is actually at UN, this is a General Assembly sought advisory opinion from International Court of Justice whether nuclear weapons, right, whether nuclear weapons are justifiable in use of force. Actually, one of our most eminent judges from Sri Lanka, Australia, Justice Veeramantri was in this panel where indeed he dissented to this judgment, but International Court of Justice in this advisory opinion held that it is not illegal to use nuclear weapons in use of force situation provided there are extreme circumstances. For example, if one country attacks another country with nuclear weapons, to resist this attack, perhaps the victim country, the victim states can also use nuclear weapons. But in a dissenting judgment given by Justice Veeramantri, obviously, the minority judgment, he said, obviously this is using nuclear weapons or threat of using nuclear weapons cannot be justifiable, right? However, when it comes to all the other judges, when it comes to American judges and Japanese, very ironically, even the Japanese judge Justice Oda also argued that it is totally acceptable provided that the use of force stays within the acceptable parameters of the international law. So back to the question of different levels, it depends on the circumstances. For example, in a small arms or weaponry context, whether you can use nuclear weapons, as per the general concept of proportionality, it would not be justifiable. However, in a very rare situation of when a country uses nuclear weapons against another country, then if the victim country also has nuclear weapons, as per international law, as it stands, as per the advisory opinion on nuclear weapons by International Court of Justice, there is no prohibition in that. But ultimately, these are hypothetical situations about different levels, and these needs further resolutions, further judicial reasoning from International Court of Justice and different research to actually solidify what are the frameworks. But for the time being, there are limitations, and most of these limitations are perhaps customary limitations and perhaps even moral limitations. But in extreme circumstances of a nuclear war, the international law would not be able to deter a victim of a nuclear attack to use force to not to revenge, but to push back a second nuclear attack, the victim also using nuclear weapons.
I think I'd like to pick up on that final point that you mentioned, sir, about pushing back against certain threats or certain advances by other nations. Sir, could you explain to us now, we have spoken about the prohibition of the use of force and the exceptions to it, and what the rule of proportionality and how it plays into different states and how they are to protect their own selves with this rule of proportionality while use of force is in place. So could you explain to us if these states have legal obligations in de-escalating tensions when it comes to use of force? Is there any?
Excellent question. Yes. De-escalation and peaceful resolution for international dispute is basically the core of the UN Charter. So whether it's from Article 1 onwards, the UN Charter is very descriptive and in fact prescriptive as well in formulating a legal mechanisms and framework in pushing countries to de-escalate. So going forward, there are several mechanisms where countries can resolve their disputes, actually many mechanisms. And these mechanisms are in UN Charter. I will discuss few due to time limitations. If a country has any conflict with another state, so suppose that, let's say, India and Pakistan has some obviously historical conflicts, countries can come down to a table like you and I and discuss this, right, through diplomatic channels. That's why we have this conventions and other instruments on diplomatic relations where countries can use diplomatic relations and negotiations to resolve. But with some countries, sometimes the negotiations are not practical, especially countries like India, Pakistan, sometimes, now a lot better relations, but historically you have situations where countries are at each other's throats. Though international law has enough or more space for negotiations, sometimes it would not be practical. So in this context, you can resort to mediation. So what is the difference between international legal negotiation versus mediation? Mediation will often involve a third party. As I think a good example is in between 2002 to 2005 era, when peace talks were going on in Sri Lanka between the LTTE and the Sri Lankan government. We know the the Sri Lankan monetary mission played a role as a mediator. So mediator is a state or entity that is independent from the conflicting parties, who has to some extent the trust of the warring parties and trying to mediate a situation. Or they could go to international arbitration. As you know, you know about international arbitration a lot these days with Pearl Harbor, etc. So that is another avenue. The most popular historical avenue, however, to go to International Court of Justice. Lot of people have a wrong idea that International Court of Justice is actually there to punish countries. No. And the International Court of Justice is there to resolve conflicts. In fact, International Court of Justice is the UN judicial arm, right? So UN has basically several organizations like General Assembly, Security Council, Secretariat, right? So there's several organizations, and International Court of Justice can be sought if the countries are willing to resolve disputes, and both countries, if the both countries are willing to de-escalate, then a great independent platform would be International Court of Justice, where the matter can be given to the eminent judges in International Court of Justice to resolve this dispute. And numerous disputes have been resolved this way. But however, the willingness of the states would be very important here, because if the states are not willing, the matter will never come to International Court of Justice. So if you see in often situations where you had war, the parties were not willing to resolve it through peaceful means, right? So ultimately, it is not the lack of international mechanisms that preclude and prevent states from de-escalating. It is the political willingness and the will of those states and the leaders of those states to resolve the disputes in a peaceful manner.
Right, so I think that's a very important context to the question that I am to pose now, and that is, now we've spoken about de-escalation. And so you mentioned about how pushing back on certain attacks will be garnered as exceptions in a sense, and how the role of proportionality as well plays in, and we just got a little bit of a insight into how the de-escalation process works as well, while that is the first and foremost. So could you explain to us now the situation of self-defense as a state? Legally, how is that justified, and how is it regulated, and are there limitations or conditions to exercising this exception of self-defense?
Excellent question. So Article 51 of the UN Charter allows, right? So Article 51 of the UN Charter states, nothing in the present Charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member state of the United Nations. So that means, despite the Article 2.4 prohibition of within the Charter, Article 51 clearly allows not only individual self-defense. That means not only like if Sri Lanka is attacked by one country, not only Sri Lanka, but collectively Sri Lanka and some other countries can get together, because often the victim state is a bit powerless after attack, to push back, or in legal terms, self-defense, right? So now the starting point that our viewers should understand about self-defense is a general misconception that people and different audience members might see self-defense. Self-defense is not reprisals. Self-defense doesn't mean like if I attack you, you attacking back because you got very angry at me. That is not self-defense. That is something that called reprisals, so revenge attacks. That is not acceptable whether in domestic law or whether in international law. So now a good case study for you would be when Al-Qaeda, under the leadership of late Osama bin Laden, attacked United States Twin Towers. What we saw is, after a few months, United States bombing and in fact invading Afghanistan. Now, this would only be legal if United States can justify this as not as a revenge reprisal attack, but rather what? You attack Afghanistan to prevent any further terrorist attacks, right? So the starting point in terms of self-defense is to understand self-defense doesn't mean revenge. Self-defense means literally what it meant, right? Defending. Secondly, this 1837 Caroline case is important, right? As per this case, The US Secretary of State noted that the right of self-defense arises only in cases where there is a necessity of self-defense, instant, overwhelming, leaving no choice of means and no moment for deliberation, nothing unreasonable and excessive. So you see, there are different limitations for self-defense. If after being attacked, if there is any other way you can resolve this issue, attacking the attacker is not within the international law. Also, it has to be proportionate. Imagine that there is a small armed skirmish at the border in between India and Pakistan, and then one country decided to put a nuclear bomb because there is some conflict that has taken place. Obviously, as you and I discussed, proportionality plays a very central point, and the next point is a necessity. States can only use self-defense if there is a real necessity. Now, when it comes to US invasion of Afghanistan, US would argue that there is a necessity in going to Afghanistan to prevent Al-Qaeda and remove Taliban back in the day, to prevent any other attacks. Indeed, even in the Ukraine conflict, obviously the Ukraine can clearly argue in all these points, right? It's not unreasonable, it's not excessive, it's not disproportionate to push the Russian invasion. As long as it can be supported rationally with reasonableness, proportionality, right? And very important, necessity, self-defense under Article 51 can be justified. But as I said earlier, taking revenge when you are attacked is never justifiable under, not only on international law, but also under any law. That is just getting emotional, being emotional and generally being illegal.
Right, so that is, I feel like in that one question you explained all the nitty-gritties that we want to know about self-defense in this specific context as well. It's a different can of worms in itself, and we have a lot more to discuss when it comes to the use of force and of course the future of use of force. Unfortunately, we've come to time in this segment, so join us again in our next segment right after this break. You're watching Law, Land and Liberty. Stay with us.
Hello, my name is Ilmin Sila and I am an IT student. My question is on the future use of force. Are there any changes to this doctrine?
Welcome back to Law, Land and Liberty. We were in discussion with attorney at law Udara Soysa, and we were talking about the use of force in an international context. Now, sir, just before we went into the break, we talked about self-defense, and you specifically mentioned Afghanistan and the US, and also we had local issues here as well with the LTTE forces and Sri Lankan military forces, and how self-defense can be justified. We were talking a lot about those nitty-gritties. Now, I think since we were on that topic in itself, it's important for us to delve a little bit further on that key issue, that is terrorism. Now, when it comes to dealing with terrorism, how can the use of force be justified, or is it justified specifically in a different means due to terrorism efforts, or is it all under one umbrella?
Wonderful question. I think this is a key contemporary theme that your audience might be very interested to learn. Now, when UN Charter back in 1940s proposed and approved, terrorism was not of a great concern at that time. But when you look at history from 1970s to 1980s, then 90s and so on, and especially after September 11 attacks in 2001, obviously we were victims of terrorist attacks way back, but you could see the notion of terrorism has become more and more prominent in international law. The key issue here is you are looking at something that we name as asymmetric warfare. Now, if Iraq and Iran has a direct war among themselves, this is symmetric because one state attacks another state. But when it comes to a terror group, right, when let's say Al-Qaeda or ISIS or Al-Nusra, right, attacking a state, but they are stationed in another state who might not even approve these activities of the group, then the present UN charter mechanisms are a little bit inadequate, because obviously the founders and the drafters of the UN charter did not live in an era in which terrorism posed such a threat to international peace and global order. As you know, in 1940s, the main issue was basically to prevent another World War III, because during that time the nuclear weapons are now into play. So in fact, another world war would, rest assured, would destroy all of us. Right? But as the history progressed, the terror groups emerged from 1970s with Israel-Palestine conflict, so on, then passing through Intifada to then, with Al-Qaeda, LTT, these groups, and you have groups in India like Lashkar-e-Taiba, etc., and ISIS now, right? What you see is the UN Charter, I wouldn't say obsolete in terms of fighting terrorism, but it needs certain modifications, because UN Charter has been tailored to state versus state conflicts, not to handle situations of terrorist attacks. However, there are several resolutions from the UN on countering terrorism. But the problem is, now imagine that there is a terrorist group in Syria attacking Sri Lanka or US or some other country. The legal framework in which the victim state can enter Syria or wherever the host nation for these terrorist groups is not very clear. While the UN resolutions have given inherent right to the victim states of terrorist attacks to take action, the legal frames to govern asymmetric warfare, especially the threats posed by terrorist groups, is not very clear-cut, because as you know, these are not interstate conflicts, these are rather asymmetric conflicts where one terrorist group attack another terrorist group, and you don't even know where this terrorist group is actually located, but some terrorist groups are located all around. Now, Al-Qaeda was difficult to maintain because they had their organizations spread across the world. So in that sense, I think the UN Charter or any other international law mechanisms perhaps need further modifications or further elaborations to check on the threat posed by these terrorist groups.
Right. So terrorism in itself is a different issue that can be accessed through use of force, and the prohibition and also the exceptions to use of force. While they are interconnected, they are not directly, there's no causal link of any sort that automatically triggers the use of force and the regulation of such. So, sir, I think we're running out of time, but I'd like to ask you, sir, a question specifically about the future of the concept of use of force. Could you tell us, sir, with the current context, now with the conflicts that we're seeing, have we seen any other, addressing from the UN or any other global institutions regarding the use of force? Has there been any changes?
As we discussed earlier, international law is not a vertical system, but rather a horizontal system. So there is no real one organization that can propose a new law and pass it like a parliamentary system. What happens in international law is there are treaties. When two states sign treaties, those are called bilateral treaties. When multiple states sign those treaties, called multilateral treaties. So ultimately, it is up to the states to come up with acceptable legal frameworks with which each other to address the issues of use of force, especially in terms of terrorism and the new developments such as R2P, responsibility to protect. Though there are, like even with R2P, there have been certain consensus, even at the UN, ultimately many states are worried to develop entirely new legal frameworks for use of force because that may be ultimately be prejudicial for those states' interests. For example, I wouldn't expect India or even Sri Lanka or China to be accepting R2P in its full might. Why? Because allowing a third state to or additional state to jump into your state and military intervene in the guise of protecting your civilians. This would fundamentally undermine the territorial integrity and political sovereignty of the state. So many states are worried when it comes to both treaties and customary international law, new frameworks in terms of use of force, because that can be a boomerang and that can backfire, and that can create avenues for very powerful states to intervene in the affairs of states that are not so powerful. Due to this reason, I think you see a level of hesitancy or global consensus to develop a overreaching legal framework that would be a new basis for use of force. So I think even for the next 10 years, I would assure you that the UN Charter would be your guiding document, perhaps surrounded by several resolutions to manage use of force.
All right. Well, I mean, there's a lot of discussion regarding the use of force, it's not that there's any necessary legislative changes that have been brought about, because in an international legal system, there is no direct impact that one resolution can have on all the nations of the world. So it's a very nuanced subject as well. Unfortunately, that's all the time we have to discuss this issue today. So thank you very much for taking the time to speak to our viewers. I'm sure a lot of our viewers are going to walk away with some key information and key knowledge in understanding the current context of use of force, especially with so many conflicts that are popping up around the world. So thank you once again, sir, for taking the time.
Thank you, Anuradhi, for having me in your show. Thank you.
All right. Well, the use of force is a very nuanced topic that I'm sure a lot of us would have wanted to understand right before this conversation, but it is something that continues to develop in the global legal field. And tonight we leave you with the words of Edmund Burke, who is an Anglo-Irish economist and philosopher. The use of force alone is but temporary. It may be subdued for a moment, but it does not remove the necessity of subduing again. That is all we have for you tonight on Law, Land and Liberty. If you missed any of today's programs, you can always rewatch by catching us on our YouTube channel, youtube.com/otherderana English. I'm Anuradhi Vikramasinghe. Thank you for watching. Have a great night.